When you think about contacting a lawyer after sexual assault, it can be a daunting prospect. I want to talk about what to expect when you contact Gerry Law about a sexual assault lawsuit. I'm Natalie Gerry, the principal lawyer and founder of Gerry Law, and I help injured people get the compensation that they deserve for their injuries, and especially sexual assault or sexual abuse survivors. We work with them to bring civil actions related to the abuse they have gone through. So, coming forward after experiencing sexual assault or sexual abuse is never easy. If you're considering legal action, you've likely already been through a lot. At Gerry Law, we represent survivors of sexual abuse in civil lawsuits. This type of lawsuit is one way to seek accountability and financial compensation for the harm you've suffered. The process is not quick, it's not simple, and it's not guaranteed. It can be stressful. It may bring up painful memories, and in some cases, it may not lead to the outcome that you hope for. But if you decide to take this path, we're here to give you the information and support that you need to make an informed choice. Step one, the first phone call. When you contact Gerry Law, your first phone call will be with an intake specialist who will ask you some general questions, and you'll have a chance to share some of your story. We treat all information as confidential. If your case is something we can help with, then a lawyer will speak with you directly and go over your legal options. Not everyone has a claim that can be pursued in civil court. There are legal, financial, and practical limits to what the civil system can offer. If we can't assist you through a lawsuit, we'll do our best to suggest other paths, like you might choose to report to police, you may access victim services, or you might file a complaint with a regulating body. We understand that sometimes survivors have spoken out before, and others are telling their story for the first time. So we'll meet you where you are, and we'll work with you at a pace that respects your comfort level. There's never any pressure to pursue a lawsuit. We will just give you information initially so that you can make that choice. Step two is investigating the case. So if you choose to move forward, our next step is to collect as much information as we can about your background, your experience, how the abuse has affected you and your life. This usually involves an in-depth conversation with your lawyer or filling out detailed forms, depending what format you're most comfortable with. Some people prefer to tell their story, and some people prefer to write it down so they can give it some thought. So this may take some time, and it will be difficult for you to recall all of the details and to put your mind back into that space. The questions will cover things like your work history, your education, your health, and any supports or treatments that you've accessed. It's common for survivors to have gaps in memory or trouble recalling details clearly, and especially when the abuse happened many years ago. So that's not a barrier to bringing a case, and memory is just one part of the evidence. So we also collect documents like therapy notes, school records, medical reports, or statements from people who knew you at the time. We may also search for other witnesses or survivors, and we may request historical records from institutions. So this is part of the process, and it can take months, and that's especially for older cases with abuse dating back sometimes decades. It's slow, detailed work, but it is necessary to build a strong case. So step three is reviewing the evidence and making a decision. So once the investigation is complete, then we'll review what we found with you. And at that point, we would give our opinion on whether there's enough evidence to move forward with a lawsuit. In some cases, there won't be enough evidence to support a legal claim, and when I speak with you, I will have to be honest about that, and you will have to know the risks with moving forward. So even then, we may still be able to help you explore other forms of justice or advocacy, even if there isn't enough evidence to pursue the civil claim. Some clients decide after the investigation that they don't want to proceed, and you might realize that you're not emotionally ready for what lies ahead in the civil lawsuit. or your personal circumstances may change, and that's understandable. For sexual assault lawsuits, there is no limitation period, so there really is no rush to file the claim. You may be able to pause, take a break, think about it, and return to it later and see how you're feeling at a later time. If you choose to proceed, then we would move on to either a demand or to the court phase. So if you decide that you want to try to resolve outside of court, then it's possible to contact the defendant and advise about the potential claim and look at resolving outside of the court process. But otherwise, then your lawsuit would proceed to starting a lawsuit, which is the actual filing of the legal documents to get your claim started. So that legal document is called a statement of claim. And I do have another video going over all the details about the statement of claim. But in a nutshell, the statement of claim begins the court process, and this can last anywhere from a year to several years. The defendants have a chance to respond. In historical abuse cases, it can take time for them to locate records and conduct their own investigations. So typically they have 20 days to respond, but they might need to look into things and might request an extension so that they can, investigate a little bit more, which is reasonable, especially when decades have passed, and they might have to go into the archives and see what information they have to prepare the defense. Eventually, both sides exchange evidence in a process called discovery. So at this point, there is the evidentiary discovery. So the documents that we are relying on, we produce to the other side. And then there's also the oral examination for discovery, where if your suit progresses to this point, you will be asked questions under oath. And this stage can be really difficult and emotional because you'll have to go through the details of what happened. And it may bring back memories that you've worked hard to manage or to even shut out, but we'll prepare you carefully and you'll know exactly what to expect. And I will be there sitting with you throughout the discovery. I do have other videos going into what discovery entails, and those will also be linked below. Most cases settle before trial, often during mediation, where both sides try to reach a fair agreement. So either at mediation, or if you're located in Northern Ontario, there's no mandatory mediation, so you can choose to mediate and potentially resolve the claim, or at pre-trial, the judge will try to resolve the claim between the parties. So not all cases settle. If no agreement is reached, then your case could go to trial, and trials are pretty rare, but they're not impossible. So the trial is what you've likely seen on TV, where the evidence is presented by witnesses. You would testify and also be cross-examined. So this can be a real process, and trials can last 5 days. They can be several weeks. It just depends how long, how much evidence there is, and how many witnesses. So even successful cases sometimes don't feel like a victory. The process can be frustrating. Delays are very common and can be really frustrating to survivors. Defendants may deny wrongdoing. You may feel scrutinized. And for many survivors, the legal process itself can feel re-traumatizing. I don't say this to discourage you, but to prepare you for what lies ahead if you choose to go ahead with a civil lawsuit. You might be wondering what compensation you could be entitled to in a civil lawsuit. So in a civil lawsuit, compensation, which is also called damages, is meant to recognize what you've been through and to help support your recovery. There are 3 main types of damages. So first of all, general damages for pain and suffering, and these are non-economic losses related to the emotional and psychological impact of the abuse. So what this means is that they're not quantifiable, like we don't submit receipts. This is what the court estimates for your pain and suffering. And when I say estimates, it is based on previous cases where judges have made decisions about what the value is of the pain and suffering that a plaintiff has gone through. So we can know approximately what you would be entitled to based on what you've gone through and if there are other similar cases. Another type of damage is income loss. So if the abuse caused you to lose work, or missed school time, you might be able to claim for lost income or reduced ability to earn income. And this is a very common one with sexual abuse survivors because frequently there are issues with completing school or issues with attending work. The third type of damages is out-of-pocket expenses. So this includes money that you've spent on therapy, medication, or other supports related to the abuse. And this can be for past expenses that you've had. And then we can also project for future expenses that you will likely have to incur to treat if you have psychological issues because of the abuse, you may need ongoing therapy and we can claim for those damages. So we calculate these damages based on what happened to you, how it's affected your life, and what courts have awarded in similar cases. Now I want to talk about some special considerations in sexual assault cases. So sexual assault or abuse cases are legally and emotionally complex. Unlike other types of personal injury claims, we often need to look at your full life story to explain how deeply the abuse has affected you. And this means collecting detailed personal information, and sometimes from many years ago. Many cases involve institutions like schools, churches, or sports organizations. And these defendants can have legal teams of lawyers, and they have insurance companies, and they all often delay or fight claims. So managing these cases does take persistence and patience. So at Gerry Law, this is the work that we do, and we understand the legal and emotional challenges involved. We know that these cases take time, and we're prepared to work with you through your case. If you want to discuss your particular circumstances, I can be reached at the contact information below. And the initial consultation is always no obligation, just to get the information and give you some insight into your legal rights.